That's what I'm known for. If
Patient.
anybody laughs, you're going. Give you a chance to talk with your attorneys about what you want to do and the process by which that will happen. You understand that, sir?
I mean, I just don't understand why I can't plead guilty, man. I mean, you can do what you got to do, but I plead guilty. I would like to plead guilty today.
Well, that can't happen. You would waive so that I can get you to a place where you can do that as soon as it's available. Is that what you want me to do?
No, I would like for you to accept my guilty plea.
Pardon?
No, I would like for you to accept.
I'm not, okay, sir, I'm not taking your plea. Pardon?
I don't know if I can make it. I'm not understanding this.
Before this exchange even begins, pay close attention to what's happening here. The judge is offering the defendant two very normal legal paths: waive the preliminary exam and move the case forward, or hold the exam and challenge the charges. Simple choices. But what unfolds next is one of those courtroom moments where the system slows down, not because the court is confused, but because the defendant might be. And when someone starts insisting on pleading guilty before the process allows it, that's when judges get very cautious. Let's see how this plays out.
Saying 3 to 10 and clearly based off of it, we talk about getting what we're looking for, right? We can send over that mitigation information and see if we can get something better, but we're better suited in circuit court if we do that. But it's totally up to you. Okay.
Plead guilty.
Sorry, Your Honor. Thank you for the court's patience. I just had to relay some information.
That's what I'm known for. If
Patient.
anybody laughs, you're going. No, go ahead.
You are a very patient man, Judge.
Go ahead. Second.
So, Your Honor, today is the date and time set for probable cause conference in this matter. I do understand my client has been deemed competent to stand trial. It tells me that he is prepared to enter a plea today. I've explained to him that that's not something that the court would be able to do at this stage. I've also explained to him that typically we would send this matter up to circuit court so that the sentencing judge will be able to properly enter his plea for him. He says that that's not something that he wishes to do. So I'm kind of at a crossroads at this point, Judge. I don't know.
So, sir, if you're going to enter a plea to these cases, it would have to go to another judge to take that plea, which is the waiver that counsel's talking about. I could not accomplish that today for you.
You can't just
Usually,
plead guilty.
Mr. Gatlin, what we do is once I've made the finding that I made today, we adjourn it out to the next available day, give you a chance to talk with your attorneys about what you want to do and the process by which that will happen. Okay? You understand that, sir?
I mean, I just don't understand why I can't plead guilty, man.
Because if you pled guilty, you'd be pleading to felony charges. Those pleas are taken before a circuit court judge, which is why it would have to be waived and you would have to go up to circuit court.
I mean, you can do what you got to do, but I plead guilty.
Well, let me do this. You've not discussed a waiver with him in detail, have you?
I mean, I have, Your Honor. I've explained to him what the waiver does and how it would send him over to circuit court with a pretrial. I've explained to him his right to the preliminary exam. I suggested that we set it for exam, but.
All right. Sir, you seem like you want to get it moving, and I don't have a problem with that. Do you want to waive so you can go up before the circuit court judge and do what you're going to do, or do you want a preliminary examination to have a hearing on the charges?
I would like to plead guilty today.
Well, that can't happen.
And here's the moment where things go sideways. In most people's minds, pleading guilty seems straightforward. Just admit it and move on, right? But legally, it's not that simple. A guilty plea waives multiple constitutional rights: the right to trial, the right to confront witnesses, the right to remain silent. Judges are required to confirm that the defendant understands every consequence before accepting it. When someone keeps repeating, "I want to plead guilty," without engaging with the process, that raises serious red flags.
To plead guilty, I can get you, you would waive so that I can get you to a place where you could do that as soon as is available. Is that what you want me to do?
No, I would like for you to accept my guilty plea.
Pardon?
No, I would like for you to accept.
I'm not, okay, sir, I'm not taking your plea. So your options are, I could set this for preliminary examination, or you can waive the preliminary examination and I will send it to circuit court where they will be more than happy to take your plea. If you don't choose either one of those, I'm adjourning the proceeding, finding good cause to do so. So, sir, what is your choice?
I don't know if I can make one.
Pardon?
I don't know if I can make it. I'm not understanding this.
All right. If there's something you're not understanding, I've got to give you time to talk to your attorney about it. So what I'm going to do is I'm going to give you the fastest date I can possibly give you to come back. Once you've had that, figure out exactly what you're doing. So I'm going to find good cause to adjourn the probable cause conference in this matter. I will adjourn it to my next date is the 9th to October 9th